No one marries intending to divorce. I'm sure that Bill and Melinda Gates would never have imagined 27 years when they tied the knot that they'd one day be announcing their divorce to the world. If they had, they might have drawn up an anti-nuptial contract, given that Bill had accumulated considerable wealth before he married. But according to Washington state law, their marriage was community property. Now, this resembles our out of community property with accrual, in that in Washington, property and debt accumulated during a marriage is classed as community property belonging to both spouses. But property acquired prior to the marriage is considered the separate property of the spouse who acquired it. Now, in South Africa, out of community or property with the accrual is considered the fairest and most equitable of all the matrimonial regimes available. But what does it actually mean? How is the accrual calculated if the marriage ends in divorce? Let me briefly review the matrimonial property regimes on offer to couples. First, the default option is in community of property. This was historically the most common regime, and it gave some protection to women who traditionally had few assets or income of their own. It ensured a divorced woman was not left destitute. The other two possibilities are out of community of property, with accrual or without accrual. In order to effect either of these regimes, there must be an anti-nuptial contract or ANC in place. Now, the role of the ANC is to define the financial consequences of the marriage should it end in divorce. It describes the terms of control and ownership of property, title of assets, and how they will be divided if the marriage ends. The ANC is a way of protecting individual rights. The out of community of property with the accrual regime strikes a balance between safeguarding the individual possessions of each spouse prior to the marriage and acknowledging the mutual support and collaboration that occurs in a marriage to add value to each spouse's net worth. Now, the meaning of accrual. Now, what in legal terms and in the context of the out of community or property regime does accrual exactly mean? The dictionary definition is the accumulation or increase of something over time, especially payment or benefits. Now, that's pretty close to the legal meaning. Now, accrual in our context refers to the net increase in the value of each spouse's estate after the marriage. The assets and liabilities they claimed before they were married remain theirs. The resources and assets they build up or accrue while they are married are classed as joint property to be divided equally should they split. It's interesting and important to note that in the definition of out of community or property, each spouse's estate is considered separate while they are married. The estates are only aggregated on divorce. At this point, the property the pair acquired during the marriage is assessed for the purpose of calculating the accrual. Now, the accrual calculation process. The accrual system may be fair, but it is undoubtedly complex. Unlike a marriage in community property, where everything is split 50-50 on divorce, in the accrual system, each spouse must tally their current assets. This includes fixed property, vehicles, cash investments, shares, furniture, insurance policies, and retirement funds, all the assets accumulated during the marriage. Now, for a couple with considerable assets or an older couple, this could be an intricate calculation. Have a look at silver splitters for a discussion of the issues faced by couples divorcing later in life. Link will be put in the description below. The next step is to deduct any assets that are specifically excluded in the anti-nuptial contract, any inheritances, legacies, or donations. It's worth noting that any debts and liabilities accrued during the marriage are then deducted, so it is a net calculation. In other words, debt incurred prior to the marriage remains the sole responsibility of that spouse and is not part of the accrual calculation. The debt incurred by either spouse during the marriage forms part of the accrual. Then each spouse deducts the initial value of their estates as defined in the anti-nuptial contract from the subtotal. This is then adjusted by the Consumer Price Index to reflect the change in the value of money over time. Finally, they each arrive at the value of their respective estates. The value of the smaller estate is deducted from the value of the larger estate. Each spouse has a 50% claim to the difference. Confused? It's almost enough to make you want to marry in community or property. Now, automatic exclusions. In addition to assets specified in the ANC, there are certain automatic exclusions from the accrual calculation. Donations between spouses, any amount awarded as injury or damages, for example, a RAF or workers' compensation claim, any inheritance, legacy, or donation, any asset acquired by virtue of its possession or former possession of the inheritance, legacy, or donation, unless the couple agreed otherwise in the ANC. Now, pension splitting. For older couples in particular, retirement funds are a crucial part of the mix, where either or both of the spouses contributes to a pension or provident fund. The value is included in the accrual calculation unless the ANC specifically excludes it. In the event of divorce, the pension interest is the benefit of the member would have been entitled to if their membership of the scheme had ended at the date of divorce. In the case of a retirement annuity, pension interest is the amount of the member's contribution right up to the date of divorce, with interest added at the prescribed rate. Now, seeking advice on matrimonial property regimes. Now, the accrual system, as I've noted, is incredibly complex. I've highlighted the key points in this talk, but there are numerous details that time just doesn't allow us to cover. If you want more information on the accrual system, the different matrimonial property regimes, or advice on an antenuptial contract, you can give us a call on 086 099 5146.